Right, I think we'll get started, and those who are still arriving will only miss a bit of the introduction. So, good morning, everybody. It's good to see so many of you joining us to hear our last webinar of the summer. So we'll be disappearing for August and be back in September. You'll be hearing our panel of experts speak today on the subject of how later life care can affect your plans for passing on wealth. For those who don't know me, my name is Tim Stovall. I'm one of the partners at Moore Kingston Smith, and I'll be chairing this morning's session. So I'm sure most of you are familiar with who we are. I can see lots of regular names on the attendee list. However, for those of you who don't know us so well, Moore Kingston Smith is a top 10 audit, tax and advisory firm with businesses across all industries, not-for-profit organisations, as well as private clients, which is the focus of today. We're part of the Moore Global Network, an international network with presence in over 100 countries. So we can also cover international matters too. Moving on to the main event, I'm delighted to welcome our panel. So firstly, Claire Edwards, who's an elder care consultant. Claire is a registered nurse who qualified from Guy's Hospital in 1983 and has gained varied experiences in both the public and private healthcare sectors, 11 years hospital-based and 23 years experience working as an independent care advisor and nurse assessor for older people. Claire's passionate about older people's right to make informed choices and quality care in an environment of their own choosing, and considers herself to be very fortunate to be able to help so many people navigate their way through such an important topic. Claire's created her own business, Claire Edwards Elder Care Consultant, in 2017, and works closely with older people and their families, solicitors, financial advisors and care providers to achieve the best possible outcomes for older people. Joining Claire from Moore Kingston Smith, we have Alison Morris, who's one of our legal partners. Alison's head of our private client legal team. She's a solicitor with over 20 years post-qualification experience and a full step member, a global professional body that helps families plan for their futures, and also a full accredited member of the Solicitors for the Elderly, a group of lawyers who specialise in acting for older and sometimes vulnerable clients. Joining Alison is Guy Serling, one of my fellow tax partners. Guy is a chartered tax advisor and been advising on personal tax for over 25 years, regularly advises on complexities of the UK tax system in an easy to understand manner, which you shall experience shortly, I hope. And then finally, last but not least, Chris Hallam is a director of Moore Kingston Smith Financial Advisors. Chris is a chartered financial planner and fellow of the Personal Finance Society. He advises individuals and families across all areas of financial planning with a focus on investment, retirement and estate planning. So I hope you'll agree that's a good spread of experts to cover today's topic of how later life care could affect my plans for passing on wealth. Bit of housekeeping before we get started. Those who are familiar with Zoom, there's a Q&A function at the bottom. You'll see that if you hover your cursor around. Please do send us your questions as our speakers are speaking. I'll try and weave those in, and those that we don't answer in the session, we'll be following up those that we're able to after the session. You'll get a feedback form once we're done, so please, it's incredibly helpful for us to help plan future sessions, so do please fill that out. And the webinar is being recorded, so you will be sent a link to the recording to watch back or to share with family or colleagues. And you'll also be sent the contact details of all of our panel as well if you want to follow up anything with them individually. So to get started, Claire, I will start with you. So first question, who should I approach to understand what care my relative requires?
Yeah, really good question. And it seems like an odd one to ask somebody what care they need when they are the ones that need the care. For most people, they are going to turn to our adult social care team within the local authority. But the term assessment is actually quite broad and is used across a number of different settings within health and social care. So adult social care are your go-to place for a care needs assessment for somebody in need of support, but assessments are also conducted by healthcare professionals such as district nurses, by care providers who are determining whether or not they can meet an individual's care needs before they accept the responsibility of caring for them, and of course community mental health teams in the context of people living with dementia. So the term assessment is quite broad, but the go-to place is the local authority, and they have a legal duty to conduct an assessment of somebody who appears to need care regardless of their financial means.
Okay, and with that in mind, what are the care options available?
Well, again, for most people, they want to remain in their own home. It's it's obviously not rocket science there. We all love our homes, of the familiarity of it. Older people in particular don't like or welcome change. So staying at home is where we would start for most people, unless, of course, the environment is unsuitable for them to receive their care. Or very sadly, for a lot of older people, loneliness is incredibly debilitating, and they reach a stage where perhaps visiting care isn't giving them the companionship and inclusion that they need, and they may be looking for an environment such as a care home in order to be part of a community and have people around them all the time. So broadly speaking, care at home is the place to start, and that can be provided through local care agencies or private caregivers who go in to meet the needs that have been identified in that assessment that's gone before. But that will also be supported by physiotherapy and occupational therapy services to make sure that the environment is safe and that the person is able to achieve their very best. So helping them to realise their best potential in terms of mobility, adaptations in equipment to keep them and their caregivers safe. So care at home isn't just about the care agencies or the carers, it's about therapists as well. And there are a whole number of other services that dovetail with that. For example, Meals on Wheels, day centres, lunch clubs and so on. There's also the option of sheltered housing, which I have to say in a lot of instances is remarkably unsheltered, so great care needs to be taken when looking at this. You can have retirement housing, which very simply is accommodation built with the needs of older people in mind, but then sheltered in terms of having a scheme manager who looks after the fabric of the building and notifies family and authorities if there are concerns. And there are also those that have, a care line system in case of emergencies out of hours, and some that have dining rooms so that all the residents can meet in a communal area every day for a cooked meal if they choose. But essentially, the care they require is arranged privately or via social services. So the third option is a care home. And if you anticipate needing a care home before too long, moving from your own home to sheltered housing could be a bit of a misstep and an unnecessary additional move. So that does need to be considered. And there are two main types of care home. There are care homes with nursing and care homes without. But obviously, as the big new builds are coming to the fore, they are tending to make sure they have a foot in every camp. So they're what we call dual registered, offering residential nursing and indeed dementia care under one roof.
And that's a lot to consider, from the care at home all the way up to the full residential care. So how do you go about finding the right provider of the care required?
Well, absolutely. So, the personal criteria of the person who needs the care has to be right up there, because if they are being taken down a path that they are not on board with, it's not going to work as well as it might otherwise do. But primarily the ability to meet the person's health and care needs. So what setting can those health and care needs be best met in? What is the personal wish list of the person who needs the care? Really importantly, of course, what funding is available, who's going to pay for this, and we'll come on to that in just a moment. Availability of rooms in care homes or availability of carers in care agencies. So those are all the things you need to think about. A lot of people use word of mouth locally. Oh, my sister's mother's in a care home up the road, so it's bound to be fine for mine. No, that's not the case at all. So do take great care there. It's useful information, but do be careful not to make decisions based on somebody else's experience alone and somebody else's needs that may be quite different. We do, of course, have the Care Quality Commission, who are the inspectorate responsible for the inspection and regulation of all care homes and all care providers and agencies and so on. And they publish inspection reports rating the care provider from inadequate to outstanding and a number of options in between, obviously. So that's always a good place to go to, provides you with a list within a certain radius of a given postcode. So it's quite a useful checklist exercise. But use the information available to you through the health and social care professionals that may be involved. District nurses are in and out of care homes. Psychiatric nurses are in and out of care homes, so they will be a good source of information on the ground. And individuals like myself, independent care advisors, can do the research for you. But don't rely on one source alone. Gather as much information from as many sources as you can.
So as you touched on, and even from personal experience with a family member in a care home, the cost of this is, really quite terrifying. What funding support is available from the state?
Well, we have a number of sources of financial support. The one that sort of comes immediately to the fore is local authority. They are responsible for supporting individuals with their personal and social care needs, not to be confused with their healthcare needs. But financial support from the local authority is subject to a financial assessment and a local authority means test. And as things stand, the threshold, just a very broad a figure, is 23,250 is the capital threshold, below which individuals could expect to get some financial support towards the cost of their care, unless, of course, they have a particularly high income. Property is disregarded in certain situations. So obviously, if you are receiving care in your own home, the property is not going to be included in that means test. Likewise, if you are one of a couple and one goes into a care home, so long as the other one remains in that property is disregarded from the means test as well. And there are a number of other disregards that can be applied. So that upper threshold is important. There's a lower threshold of 14,250, and individuals with savings and investments below that figure is ring-fenced from care costs. So individuals can't be asked to contribute out of that money, though they can be asked to contribute out of savings and investments that fall in between the two thresholds, 14,250 and 23,250. The next source of financial support is from the NHS, which clearly focuses on healthcare. And of course, our GPs, district nurses, hospitals are really good examples of this. But in the context of older people and their care, there are a number of additional sources of financial support that a lot of people are not aware of. So, for example, if you are supporting somebody in their own home and they become very poorly unexpectedly, but there's an attempt to avoid an unnecessary hospital admission, there is something called rapid response, where a team of nurses and therapists will descend, albeit for a very short period, to try and prevent hospital admission. And that care in the home is at that point completely free of charge, regardless of means. Likewise, on the other end of a hospital stay, when people are discharged from hospital, they often need time to recoup and rehabilitate from their illness that took them in there in the first place. And we have something called discharge to assess, which is really to prevent people remaining in hospital unnecessarily. Let's face it, none of us want to be in an acute hospital bed any longer than we need to be, but also to release those hospital beds for the people flowing in through A&E. So discharge to assess is care that's put in place either at home or in a care home setting for up to 4 weeks, free of charge, funded by the NHS and local authority, whilst assessments of long-term care need are conducted. So this is very specifically for people who are recognised as needing new or enhanced care arrangements when they are discharged from hospital. It's not available to all, it's subject to local protocol. But one of those assessments that will be conducted alongside the care needs assessment I referenced at the beginning of this session by local authority is a consideration of for eligibility for NHS continuing healthcare funding. And that is full funding from the NHS paid to individuals with a primary health need. Now, you could be forgiven for thinking that people in care homes the length and breadth of the country with Parkinson's, stroke, dementia and so on must surely have a primary health need. And very sadly and frustratingly for myself and families together, it's not that simple. It's not based on diagnosis alone. It's based on the care that somebody needs as a consequence of those conditions. So there are people in care homes who don't qualify for full funding under NHS continuing healthcare funding, but if they do nonetheless have a need for nursing care and they are in a care home with nursing, they will get something called the NHS funded nursing payment, which is currently £219.71p. Don't know what the 1p is for, and that's per week. So that's sort of a quick snapshot of NHS funding, very much based on health need. We also, of course, have the Department of Work and Pensions, and they have a whole raft of benefits to individuals, some of which are intended to raise people's income, and some are disability-related benefits. And just a very quick snapshot there. Attendance allowance, really, really important to take on board. This is not means tested. Is paid to individuals who need support in any setting, so long as they are privately funding their care residential wise. They can be receiving financial support from the state in their own home, but it is one of the most underclaimed benefits. It's paid to people who need support, regardless of whether they are in receipt of that support. So really important one to take on board. And carers allowance for people who are caring for an individual for over 35 hours a week, though sadly that is means tested at an incredibly low level and sadly doesn't benefit an awful lot of people. And the private purse, obviously really the importance of seeking financial advice, and Chris will no doubt be touching on that too. So I think that's a bit of a quick overview of funding.
And I thought the tax system was complicated, right? We've had a question in which I think all of the panelists will probably have something to say on, but this is around giving away assets and when you've been talking about means testing, Claire. So the question is, if mum at 79 gives part of her home to her children and at 89 needs care, can the system demand that the gift is not valid? So I think in the context of your question, giving away assets, how does that affect the means testing?
Yeah, absolutely. So this is called deprivation of assets, which is all about timing and intent. And it's something that families can fall into quite easily. If somebody does gift money to somebody else at a time when they might reasonably expect to need care and become dependent on the local authority for the funding of that care, the local authority can treat you as if you did still have that money, so they can charge you notionally. But, you know, I think you shouldn't let that put you off getting the care needs assessment and financial assessment, because, you know, I can't say to you definitely it will be treated as deprivation of assets or not.
Yeah,
Something to be careful of.
Part of the reason of the question, I suspect it's been difficult to get a categorical answer because it is such a subjective area. Okay, thanks for that, Claire. So moving on then. So I always find you've talked about approaching social services and NHS. I never know who to speak to. So who are the best people to speak to within NHS and social services? Yeah,
well, the important point here is the GP is the gateway to all healthcare services. So if you are experiencing health concerns, the GP is the best person to go to. They can direct you to the specialist consultants. They can direct you to the specialist nurses, for example, Parkinson's nurses, community psychiatric nurses. They can direct you and refer you to occupational therapy, physiotherapy, speech and language therapists. And of course, within the adult social care team, separate from the NHS, you can call them direct. And you can speak to an advisor at the adult social care team, and they will also direct your call and obviously allocate a social worker to you if the case demands that.
Okay, we just had a good comment in from one of the attendees that they successfully claimed attendance allowance for both of their parents, and they found Age UK a great help. So I think that presumably Age UK are another great resource here.
Oh, absolutely. There's a whole raft of charities like Age UK and Alzheimer's societies, and their websites are really, really good resources, excellent fact sheets.
Okay, so here we get into the more difficult areas. What can I do if my relative and I disagree about the most suitable care option for them?
Yeah, hugely frustrating, but very, very important for the older person that everybody involved determines who is the decision maker very early on. So if an older person has mental capacity to make decisions for themselves, they absolutely must be permitted to do that. And sadly, the law, well, from the sons and daughters' point of view, the law states quite clearly that people have the right to make what others might consider to be unwise decisions. It's frustrating, but if you put yourselves in the shoes of an 80-year-old, you're not going to want your children telling you what to do. So, you know, it's quite simple in that respect. This obviously links in very well to lasting power of attorney, making sure that you appoint somebody to manage your affairs in the event you're later unable to do so yourself. If that attorneyship isn't in place, and certainly with health and welfare decisions, I would be looking to see whether the person had a lasting power of attorney for health and welfare if they didn't have capacity to make the decisions for themselves. If that's not the case, any decisions made must be made in the best interests of the older person, not for the convenience of the sons and daughters. So that's also an important point to take on board. And I think Alison will be touching on power of attorney herself as well.
And with your experience in many different roles, Claire, any tips for these difficult conversations? What's worked well for you?
Yeah, well, there's a reason why we've got 2 ears and 1 mouth. And I just think, you know, it's just so very important to listen to the older person you're trying to support, even if sometimes they're not as clear as they would have liked to have been. It's an incredibly emotional subject. Tread very, very carefully. And I often use the term, you know, sow the seeds rather than crack the nut. So have the conversation gently and carefully, but don't try and tick all of your boxes with some of these early conversations. It's just a very, very emotional and sensitive path. And if you're not careful, the older person will pull up their drawbridge and you'll find it very difficult to support them.
Yeah, I mean, we talk to our clients, a rare occasion, families all get around the table, Christmas being one of them, that people now plan the difficult conversations after the turkey's been put away. But
exactly.
Yeah, okay. Well, look, thank you for that. For the attendees, we will be circulating Claire's details. I mean, to squeeze that much content into 20 minutes is amazing, but Claire is an amazing resource that I'm sure you'll all find helpful. So you'll have her details afterwards. Right, Claire, thank you. Guy, moving on to you. So we're moving on to tax. I suppose this links back to one of the earlier questions. So if I'm considering giving assets away, so we're on to passing on wealth now, giving assets away to family members, what tax issues do I need to think about?
Well, thank you, Tim. Yeah, good point. So the main tax issues relate to capital gains tax and inheritance tax. However, care also needs to be taken around stamp duty, land tax, SDLT, if a property is being gifted. If we start with IHT, a gift from one individual to another is called a PET, which is a potentially exempt transfer. This means that it's not immediately chargeable to inheritance tax, but could be if the transferor dies within 7 years of making the gift. Provided the donor survives at least 3 years from the gift, then there is a reduction in the amount of IHT payable, with a 20% reduction in the tax that's due for each complete year starting 3 years after the gift. That there is a common misconception that it's the value of the gift which is incorrect. It's actually the amount of the tax that's reduced. So if the gift falls within an individual's nil rate band, there is no reduction in the value transferred when considering the deceased estate, and so no reduction in their IHT. So moving to capital gains tax, a transfer other than cash is deemed to be made at the market value of the transfer, even if no cash is received. So going back to your example, the question that was raised earlier, gift of part of the main residence, that should be exempt from capital gains tax. Now there's further points to consider on that, and I'll sort of come back to that in a later point in the sort of one of the questions.
We've had a follow-up question on precisely that point, guys. So
okay.
Come to it. Okay.
All right. Yes. Yep. That is correct from the non-centennial. So yes, stealing my thunder, one of the tax traps to be wary of. But yes, I'll go into that in more detail. Yes.
So the last weekend's newspapers were predicting that IHT was going to be abolished. What's your view on that, Guy? Is that likely to happen?
Well, last year, to the 5th of April 2023, they raised £7.1 billion so from IHT. So in the current state of the economy and trying to raise as much money as possible, if they cancel IHT, they need to replace it with something else. Yeah. And then also as to which part of the electorate that would be benefiting is maybe something that needs to be considered. But I won't go into that. It's a bit of a political conversation. Yep.
IHT, capital gains tax, and stamp duty land tax are all problems with giving assets away.
Yep.
But what IHT exemptions are there?
Well, you've got the main exemption of the nil rate band of £325,000. So if your estate is worth less than £325,000, then there's no inheritance tax to pay. There's also the residence nil rate band of £175,000, and that's when you pass your home to a lineal descendant through your estate. There are complete exemptions for transfers to surviving spouses or civil partners, although this can be complicated if one party is a non-UK domiciled individual and the other is UK domiciled. Assets qualifying for business relief, and these must have been held for at least 2 years before death, they also qualify for exemption from IHT. Now, there are two rates, one at 100% and one at 50%. So interest in a trading business that's passed on to family members, or shares in an unquoted trading company that are passed on to family members, those qualify for the 100% relief. And if you have land or buildings which are used wholly or mainly in a partnership of which you're a partner, or a limited company of which you have control, then 50% of that value is exempt from inheritance tax. And then inheritance tax is payable at 40% on the net value of the estate above the exempt amounts.
So business relief is ever so important for a lot of our clients, although their main home might be a big asset, the value of their business could dwarf that. But it sounds like Guy will be fully relieved from inheritance tax.
It should be. You need to be careful of accepted assets within the business, and the main one of those is cash or investments, and that can reduce the amount of the value that's exempted. But the benefit of that is it's not an all or nothing relief. You'd look at the value of the business and look at what proportion of that relates to accepted assets, and that proportion then is chargeable to IHT, but the balance is exempt from inheritance tax.
If you've got something other than a wholly trading company, you need to take care. So
yes.
A lot of our clients, where they want to pass wealth down the generation, might be a little nervous about giving their children one generation down, large pots of cash or assets. What happens if assets are transferred to a trust for family members rather than directly?
Well, so a trust is a transfer to a trust is a chargeable lifetime transfer. So this is different to a potentially exempt transfer, and this means that the value transferred to the trust, if it exceeds the nil rate band of £325,000, there's an immediate lifetime tax of 20% on the excess, and that can be higher if the trust is paying the tax. IHT can also be charged on each 10-year anniversary of the trust's creation, and that's charged at 6% and also on capital distributions from the trust between each 10-year anniversary, and that's at a pro rate of the 6%. Now, this is where you can put, going back to the business assets, putting business assets into a trust, you can exceed the £325,000 because it's not immediately chargeable to IHT, but non-business assets would be subject to IHT and going into the trust.
Yeah. Sorry, there's a question that's come in just to clarify a point earlier. I almost picked you off on it because in tax we love a bit of jargon.
Yes.
In order to benefit from the residence nil rate band, the property, the home needs to pass to a lineal descendant. Can you just explain who lineal descendants are?
So that'll be children and grandchildren.
So nieces and nephews? Not
nieces and nephews. No. So your own children. So yes, unfortunately not.
Okay. So trusts, have a degree of complexity to them, but have their place. What other tax traps are there that people need to be aware of that we come across?
So the residence nil rate band of £175,000 that I referred to, that's restricted if the individual's estate exceeds £2 million, and so that's if the individual's estate exceeds £2,350,000, then they get that is reduced to nil. So consideration should be given to transferring half of the family home to lineal descendants on the first death, and the property would, in this situation, would need to be held as tenants in common rather than joint tenants, so it doesn't pass by survivorship. And there's also scope for deathbed planning, and that's to make gifts to individuals to bring the estate value below £2 million before death.
Mm.
And then, so one tax opportunity, and it sort of comes into a question on business relief if it's passed on to organisations such as not-for-profit. It's passing IHT BR qualifying assets to a discretionary trust on death instead of a surviving spouse, because we have the spouse exemption for assets. We also have business relief for assets qualifying. And so passing into a trust, you can get the assets into the trust in a tax efficient way. And then the trust, it's provided it still holds the assets at each 10-year anniversary, then they will continue to be exempt from inheritance tax.
Yeah, but the point there being business relief isn't conditional upon the asset being left to a family member. You can leave a business relievable asset to anybody and the relief still applies.
That's correct.
Can we just go back to the example of giving home away, because this one comes up so often? So where individuals give their home away to their children, thinking that they're curing their inheritance tax problem, what happens there, Guy?
Well, making a gift of an asset and retaining a benefit can lead to the asset remaining in the individual's estate for inheritance tax purposes. And this is giving away your home and continuing to live in it. And so this is called a gift with reservation of benefit. And so giving away part of your home, potentially, yes, that's a way of dealing with it. But that's if children are living there and contributing to the cost of the property. So if you give away part of the property but to children and they don't live in the property, then that will stay within your estate for inheritance tax purposes.
Yeah, we see it so often where people think they've done their inheritance tax planning themselves by giving all their assets away, but continuing to live in it. And we'll just do one final question, Guy, then I'm going to cut you off, I'm afraid, unfairly, which is a good one that comes up, which is a bit around furnished holiday lets. So if somebody's got a furnished holiday let, so a nice place by the seaside perhaps that they rent out, which has a particular tax status, how does that work with business relief? Because property lettings normally wouldn't qualify for business relief.
Well, furnished holiday lets are an interesting example. There are various income tax reliefs that they qualify for, and there have been several cases regarding whether they would qualify for business relief. And one of the key point on this is what additional services are being supplied. And so if someone collects the key, they go in, they stay in the property, and then they leave at the end of their week, and you've done nothing for them, then there's no business activity there. You would have to do an awful lot to be able to convince the revenue that you're doing that, running a business. That would be welcoming them, taking them around, showing them around the local area, giving them details of where museums are, spending a lot of time with them. That would be the evidence that you are running a business rather than it is an investment.
Yeah, there's reams of case law around caravan parks on this point. So I think to the attendees asked question, great care must be taken in treating furnished holiday lets as a business for IHT purposes, even though it's treated in favourable ways for capital gains and income tax purposes. Right, Guy, I'm going to cut you off unfairly. We've got a few questions on tax that we've not got to, which we'll wrap up at the end or afterwards. So I think I'm now moving on to Alison. So Guy, thank you. Alison, our head of private client legal. So we guys covered, and I think it must be in the minds of many of our attendees, problems around giving away your home. So we've got some tax traps, we've got some care funding traps around deprivation of assets. What legal traps are there?
Thanks, Tim. Yeah, well, if you, it sounds a bit simplistic, doesn't it, really? But if you give away assets, you can't get them back. So you need to be very careful that you can ensure that you can, afford to carry on living in the same way you would have wanted to live before you gave those assets away. Quite often, we find that when people give a half share of their home to their children, they don't think about the fact that the child could die, in which case that half share of the home could pass under the child's will and go to somebody else. You could be forced out of your home. The child could go through divorce proceedings. We never know what's going on behind closed doors. you might think the relationship's fantastic, but if it does go through divorce proceedings, then it will be taken into account in any financial settlement. And again, you could be, forced out your home, or have to buy your ex in-law out somehow or other. You might not have the funds to do that. And then, of course, there's bankruptcy. So if your child becomes bankrupt, then the trustee in bankruptcy can come after you. So you could lose your home that way as well. Claire mentioned deprivation of capital rules. If there's any connection whatsoever between you giving away part of your home or your home in order to deliberately deprive yourself of capital and avoid the payment of car fees, then the local authority can come after you, and they will assess you as though you still own that asset. And if you haven't got the money to pay for that, then they will then go against the recipient and even commence insolvency proceedings. So
I remember going along to see a barrister with a client to talk about inheritance tax planning with the family home, and the conference with the barrister opened up with, your family home is the last thing you do your inheritance tax planning on for all these reasons. So that's, I mean, it's certainly possible to do inheritance tax planning and planning more generally with the family home, but it can get complicated. So lots of help needed.
Very much so. And there's a big difference between the local authority care home and a private home as well, which Claire will tell you. You give away assets like that, you fall down to your 23,250. You need, the financial assessment says, well, you need to be looked after in a local authority home. You're then sent to the other side of the county, away from friends and family, into a local authority assisted home where they've got a spare room. You're not in a lovely private home, which are like 5-star hotels nowadays. I know where I'd rather be.
I know the cost is similar to a 5-star hotel, but look, we'll move on to lasting powers of attorney, which both Claire and Guy have met. We did have a question in earlier, which I've been saving up until now, which is, are enduring powers of attorney still valid?
Yes, they are. Yes, they were put in place before lasting powers of attorney. They operate like an ordinary power of attorney insofar as you appoint attorneys to act on your behalf and manage your property and financial affairs. Because you're physically incapable of dealing with it, you could be blind or physically frail and just need your attorneys to act on your instructions. But the attorneys have a legal duty to register that enduring power of attorney with the Office of the Public Guardian as soon as they have reason to believe that you are or becoming mentally incapable of managing your property and financial affairs. And of course, that's a subjective test. So we find that most attorneys leave it till the very last moment to register it because they can't have that difficult conversation with their parents to say, look, we think you're losing mental capacity. Nobody wants to hear that, do they?
So with lasting powers of attorney, what are they and why should you consider putting them in place?
The lasting powers of attorney came into force in 2007. They replaced enduring powers of attorney because there was a feeling there was enduring powers of attorney could cause financial abuse. You're up and running as an attorney at the moment. Somebody signed that enduring power of attorney, and they were allowed to. They could take monies away from your bank account, etc. There's no supervision. I mean, we don't know how many enduring powers of attorney are out there, which are being used whilst the person's mentally incapable. There's no onus on you to register that and have that under being seen by the Office of Public Guardian. So lasting powers of attorney replaced enduring powers of attorney, and they last despite the onset of mental incapacity. They're legal documents whereby you appoint people you trust implicitly to manage your property and financial affairs or make health and welfare decisions for you if you lack the mental capacity in the future to make those decisions for yourself. There were two types, as I've just mentioned. There's property and financial affairs, and there's health and welfare ones. The property and financial affairs ones, once the LPAs are registered, the attorneys can start acting immediately, obviously acting on your instructions. But if you were to lose mental capacity, they can carry on acting for you. The health and welfare lasting powers of attorney, your attorneys can only act if you lack the mental capacity to make those decisions for yourself, because of course, whilst we retain mental capacity, we decide where we live, how we dress, who we see, whether or not we refuse or give consent to medical treatment.
And are they easy to put in place? I mean, it all sounds like it's a complicated legal document to me.
Yeah, the trouble is that when they came into force in 2007, they were incredibly complex. They were 25 pages long. They were new documents. They were heavily criticised by the Law Society, STEP, SFE. People got them wrong very quickly because the certificate provider had to tick a box to say they were over 18. We had LPAs rejected because doctors had said the person had mental capacity but hadn't ticked to say they were over 18, so they were sent back. We had, we had a JP once who said that I've known my friend for 40 years. She hadn't ticked the box to say she was over 18, so they rejected that as well. So there's a lot of upset about the LPAs, and they were very long-winded, and people found them very difficult. And of course, the public guardian, if he had his way, he would make sure that everybody had a LPA in place from the age of 18. So they were being made easier, and 3 versions of the forms further down the line, you can now put them in place online. So yes, they are easy to put in place, but no, they're not really, because they've been dumbed down so much. There are lots of traps as you put the LPA in place. For example, if you sign as J.A. Smith, but you put your name down as John Smith, then it's rejected because you haven't provided your full name. We've had LPAs rejected because there aren't postcodes, etc. What I find with LPAs is people who do them online, it may seem simple, but they haven't really thought it through properly. So how attorneys are appointed, how should they act? Jointly and severally, or jointly for some decisions, or jointly and severally for others. And then they put in a document which becomes almost unworkable because they say, oh, it's going to be only jointly for certain things, and it has to be jointly only if you're going to sell my house. And then one of the attorneys dies and you can't sell the house because that decision had to be a joint one, and any joint appointment immediately fails if the other attorney can't act. The other common one is the appointment of replacement attorneys. People seem to think that the replacement attorney can step in to act the moment the original attorney can't act. We use that sort of loosely, can't act. What does can't act mean? Does it mean they're in hospital? Does it mean they're on holiday? No, the replacement attorney can only step in if there's a triggering event, and that's death, if the attorney disclaims mental incapacity, bankruptcy, or if they're married to the person who put the power in place, divorce. So just because, if you appoint your wife as your sole attorney and your 2 children as your replacement attorneys, and your wife goes into hospital and can't act, the replacement attorneys can't step in. So you really need to think about that. And then also, lots of people don't bother putting in their wishes. You got the chance to make it a bespoke document. You could say in your property and financial affairs LPA, I want to be looked after in my own home for as long as possible, even though the cost of such care may deplete my estate. You're protecting your attorneys. Everybody can see that, by being an attorney and providing care for that person in their home, which might be a lot more expensive than a private care home, that's what you wanted, and you're not going to face adverse criticism afterwards from the beneficiaries of your estate. And you can put in preferences. You could say, I'm a vegetarian. I don't want to be given any meat-based products. I know that sounds simple, but if I were to lose mental capacity, I would. Yeah, it is really, really important. If I were to lose mental capacity and I went into a care home, I don't eat meat. I wouldn't want to be given pureed meat. It's quite important you put all this in.
So the online nature of LPAs, I think, in answer to the question, are easy to put in place. They're deceptively difficult, and we see lots of people put them in place themselves. But all of these factors need to be considered. Now, just to give Chris adequate airtime, I'm going to just take a one-sentence reply to you on your final question, Alison, which is how long does it take to put LPAs in place?
It's taking a long time. It's taking at least 5 months. So if there's any urgency, what goes around comes around. Put in place an ordinary power of attorney so your attorneys can act immediately. treat it as a temporary measure until the LPA is registered, and also consider putting in place an advanced decision, which used to be a living will, so that your healthcare professionals know what treatment you wouldn't want and in what circumstances.
So the process of preparing them is quite straightforward. It's the registering that seems to take the time, as with many things that involve the government these days. Okay, good. Right, well, government agencies. Thank you, Alison. We'll come back to you. There's lots of questions that come in, lots of them around tax. We're going to try and get through to those at the end. But I just on Chris's topic. So Chris, being a financial planner, all of this has to be paid for. So long-term care is a big concern for people approaching retirement. How should people, how should people plan for it?
Yeah, I mean, it's a great question, and one that sort of in pretty much every meeting we have with clients, where they're discussing their plans, maybe after work, or they're still sort of working towards that point of financial independence. One of the biggest concerns is always what do I do about care? At some point, I might need to go into it, or my other half might need to go into it, and where you see it at the moment, I mean, it's been in the media so much in the last couple of years. It's really the costs of this is incredibly sort of evident, and then that's leaving aside sort of people's experiences through COVID and everything else, which has really brought this to the forefront of everybody's mind. So, it's something that I would always say, plan early for it. And the sooner you sort of think about actually what these eventualities might look like, the the easier time you're going to have doing it. And when we sort of look at this, and we do some fairly sophisticated sort of cash flow modeling for clients and planning for clients, which really helps sort of forecast these things through. Care is a very, very difficult one to model around. There are so many uncertainties as to what it's going to look like, not least because you don't know when it will happen, but you also don't know what it will look like. So care takes a lot of different forms. Claire went through sort of various different types of care, and all of them coming with their associated costs. But the other one is also just length of time. It's very possible that people have very, very short, very, very expensive periods of care. Care might be a much longer term thing that you need to plan for, and that's all going to be done in sort of different ways. So, a little bit of uncertainty as to how you do that, but you've got this position where actually having some flexibility in your savings, in your investments, in your plan is going to be key, and so that you have the ability to find large sums of cash if you need them short term. Quite frequently have people that maybe sort of use private as their first point of call. If it's sort of something which isn't enduring and they can get sort of looked after quickly, then making sure you've got assets available that can be taken out fairly quickly. The other sort of one that clients I think get quite wrong sometimes is about life expectancy, and it's a case where it's very easy to sit looking at 65, 70 and looking at a pot of money and think, oh, I've maybe got enough. I'll be sort of fine. Our life expectancy. I mean, life expectancy now for a man aged 65 is about 85 years old. It's a couple of years older for a woman. That tends to be a starting point for a lot of clients when they come to planning, thinking, well, now I'm going to need an income until I'm 85 or there and thereabouts. Actually, that's fine as an average, but there's sort of 25% on statistically at the moment anyway, about 25% of people will go on to sort of 92 on that, and about 10% of people go on to about 96. So there is a huge portion of people that actually will go far beyond that average life expectancy. So something that we work very closely with clients is just having an understanding of that long term. So making a decision now, maybe when you're early in retirement, and Guy talks a lot about gifting and inheritance tax, but knowing that, actually, yes, it's probably going to be affordable immediately and maybe even in 5 years' time. Actually, where it's going to impact you is at the other end. And that's exactly where care fees are coming in, and exactly where you're actually going to need some of those funds, and where they're going to be even more important. We can talk a little bit about sort of funding and what people look at, and it's very dependent on a client's overall sort of circumstances, but also on the risk that they're sort of prepared to take as well. I mentioned sort of flexibility. That's a really important area. So making sure that you have the ability to access funds when you need them. There's nothing worse than sort of clients potentially with assets that are illiquid or locked up. Obviously, property is one of these. There are ways around that, but actually making sure that, you know, if you do need funds, you can have it. I mean, the typical long-term savings for clients being sort of pensions, and one of the bigger ones are investment pots sat around that, being able to draw on when you can. Obviously, the family home is one of the biggest assets in most people's sort of, you know, wealth and investments, and it's something which we always sort of are obviously mindful on in planning, that there is a significant amount of wealth there, but you know, you don't necessarily treat it as an investment because it is a lifestyle asset, but it is a nice fallback for people later on. In the absolute worst case scenario, you do know that there is a family home behind. So being very, very mindful and almost using that sometimes as a last resort emergency funds, just to give a little bit of sort of confidence or comfort in, you know, the fact that actually long term, even if everything else goes, you do have a solid asset there. So just being mindful of how much you're giving away and what you're sort of doing with it.
Okay, and we often see with clients, or even in my own household, you know, one party to a marriage perhaps, you know, deals with all the finances, knows where all the skeletons are buried, and one person, you know, doesn't. You know, how do you deal with that if you're worried about what would happen if the person who manages finances is no longer there to carry out that role?
Yeah, it's something we see a lot with sort of one person or one partner dealing with things. You know, maybe potentially they were the main sort of earner or something, or it's sort of sat with them. I mean, we hugely encourage getting other people involved. I mean, not least from the person whose responsibility it is looking after the finances for however many years. It's a really, really big worry that, you know, their family is not going to be confident or comfortable sort of dealing with it in a way that they've been obviously comfortable with for years, and they know where everything is, and then they know how to do it, and they know who the advisors are. And so really the sooner you can actually bring in your family to these sort of discussions. I mean, Guy spoke a lot about inheritance tax. It applies equally well there. I like sort of how Claire was putting it on the kind of care conversations and things. It's exactly the same thing, and it's not something that needs to be done all in one go. Actually, you don't need to choose to tell everybody everything all at one time, but we really sort of encourage everybody to get a little bit engaged in what the financial position is. Yes, they don't need the day-to-day sort of monitoring of it necessarily, or involved in everything, but as soon as you can sort of help educate your family around you and help them sort of get into a position, and that's going to make it much easier when they do at some point either need to sort of look after these finances because you've lost mental capacity, or actually sort of later on when they're inheriting these funds, getting them to a position where they're ready to receive what can sometimes be significant sums of money. Get them ready for it. And I mean, the other one on that, and sort of a bit of a plug, but we're all sat here as professional advisors. One of the biggest things is having a team around you as an individual who is also there to help when these things happen. I mean, we sit there with clients and we understand sort of, you know, client needs and what their thoughts and objectives were really well, and we're, you know, can be in a perfectly placed position to actually help the family after that. So sort of making use of those sort of professionals and those people around you that are helping.
Yeah. Okay, I'm going to go into a quick fire round, if I may, and see if we can tackle. We've got a few questions outstanding, so I'm going to start with one for you, Chris, as you're our last speaker. So, my sort of toes curled as I read this, as it had a sort of slightly dirty reputation years gone by. But so with the home as an asset and the implications of raising funds, are you talking about equity release?
Yes. Equity release is an interesting one. So, you know, it's something which I think has arguably been missold quite a lot in the past, and probably still is. If you have you still have adverts on TV talking about how you can do equity release and then go on a nice holiday and buy a car, which I suggest is not the way to go. But equity release done right is can be an incredibly important product for clients. Need to be very, very aware of what it means as far as, you know, potential inheritance tax in the future goes. But it can provide flexibility of taking down money from and effectively in a liquid asset. It can certainly be useful in instances where actually maybe one of the most important things is remaining in the home. and that is a huge goal for a lot of people. So absolutely, it can be used, but really caveated with the risks and the expenses around it.
It's got its place. Probably don't bring up the name in the back of the newspaper or the daytime TV ads, but there are reputable advisors out there who can advise on it. Right, quick fire round. So one for you, Alison. I already have both LPOs in place. Should I be lodging the health one at my mother's GP now, or wait until she gets to a point where she's lost her mental capacity completely?
Get it lodged now. Get it scanned onto the medical records now, so that they know it's in place. Yeah.
Oh, quicker than I was expecting. I'm going to go back to.
Well, I can go further.
No. I'm going to get through as many as we can. So, got one for you, Guy, if you want to unmute. So, is the lineal descendants test? We're back to the resident nil rate band, where the extra inheritance tax exemptions available for the family home where it's left in a certain way. Is the lineal descendants test satisfied if the main residence is left on trust for children and grandchildren on death?
I will need to double check that point. Don't immediately know the answer to that.
Oh, well, that will be a follow-up question. Okay, so we'll capture that in the Q&A log.
Yep.
One that I think probably on slightly safer territory. So a question on giving cash away. How much cash can be given away in any given period? My son lives in Australia and I'd like to pay for his flights back to the UK. So the broader question is there any limit on how much you can give away?
Well, the answer to that is no, you can give as much as you want, provided you survive 7 years. You do have exemptions, so you can give up to £3,000 per year, and that's immediately exempt. And another question that's raised is gifts out of excess income. So I don't know if you wanted
that was going to be my next one.
Next question. So that's leading into that.
Let me just frame the question. So gifts in the main, you have to survive 7 years, as most people know. The least used and but most powerful inheritance tax exemption is the one we're referring to here. So gifts out of income. So the question is payments out of income for school fees for grandchildren liable to the 7-year rule?
The answer is maybe not. So you need to look at your personal circumstances, look at your income. If you have excess income and the amount you're paying on school fees is within that excess income level, and you are regularly paying it, which in my experience, school fees you do regularly pay, then that potentially should fall outside your estate immediately, so you don't have to wait the 7 years.
Yeah, so gifts out of income, although it keeps getting referred to by the press as a loophole, is a very well established exemption that allows you to give away, limitless amounts without having to survive 7 years, but again with care and with good advice. And then I think last one, no, maybe not the last one for you, Guy. We'll keep going on you. So if the father dies and then later the mother dies, and they had 2 children, do they have the ability to claim 2 nil rate bands and 2 resident nil rate bands? So just want to explain the circumstances where they'll be able to claim.
That's correct. So the nil rate bands are transferable to surviving spouse or civil partner. So when the first spouse dies, the 325,000 and 175,000 passes to the surviving spouse. So in the example where the estate is worth £1 million, then on the second death, there's no inheritance tax, provided it all passes directly to the lineal descendants, the 2 children.
Yeah, there is a bit of a push to simplify inheritance tax, so we might one day see the resident nil rate band combined with the main nil rate band. Just picking out questions which can be answered in a quick fire fashion. So I think the one about the resident nil rate bands, we've done that one. I think I'll probably, rather than try and reduce some of the longer questions down to an easily answerable form, I may at that point just ask for any closing comments from the panelists. Is there anything else you'd like to say as parting shots? I think the one which I didn't get to, no, I think I got to everything with you, Claire, and grateful for your assistance. So as I said at the beginning, this is our last webinar before we break for the summer. We don't generally run one in August. Do please fill out the feedback forms. Let us know if there's any other topics you would like to hear about. And as I said, and I'll say again for any of the late joiners, there will be a recording of this webinar circulated to all the people who registered, whether they attended or not, together with some questions and answer logs. So if the questions that weren't answered live, you'll get to see those in the log. And you'll also get the contact details of all of the attendees as well. In particular, Claire is an absolute expert in her field, so do please reach out to her with questions around care. So it just leaves me to thank you all for attending and thank our panel, and have a good rest of the day.
Thanks, Tim.
Thank you.
Thank you.